Previous parts gave you the permanent architecture, why institutions exist, what tensions define them, how to structure an answer, etc. This part does something different. It takes the actual events of the last 12 to 15 months and show you exactly which scene each one plugs into. This is the deliberate. UPSC does not invent a new constitutional theory every year. It takes something that happened. It takes something it happened and asks you to reason through it using the frameworks you already have. In previous classes, we discussed it. If you read previous parts, every current affairs item below should feel like a return, not a new topic. That is exactly the mental habit this script has been building from scene 7 onwards. Read a current event, ask which constitutional principle is involved, then write the answer using the principle. Each scene below follows the same format, like what happened, why it matters, what happened, and why it matters constitutionally, which earlier scene it extends, and the exact shape of a likely question. And one scope clarification here, stated once honestly, what is that? This marathon covers the polity and governance of half of GS2 paper. Polity and governance, half of GS2 paper. The international relations, half of the paper, needs to own separate track. No scene here substitutes for it. Simply, till then, we discussed more or less static point. Now onwards, we discussed current bridge from which discussed in the previous classes. Then we are moving to first scene, that is the 2025 presidential reference, governors, timelines, and the limits of judicial review. This is the extents chapter 7, scene number 13b, the governor. We discussed in the previous classes. So this is without question the single most important current affairs development for the governor topic in years. Why? Why this is most important? Possibly the most important since Bomma itself. Why? You need to know this sequence precisely before moving that, because it has two distinct halves and UPSC will expect you to know both. So, first half. What is the first half? April 8th, 2025. A two-judge bench of the Supreme Court in state of Tamil Nadu versus Governor of Tamil Nadu held that Governor R.N. Ravi's indefinite pendency on 10 bills was illegal. The court went further than any previous ruling. It laid down specific timelines for governors to act, held the governor has no pocket veto, and using Article 142 declared the 10 pending bills deemed to have received assent on the date they were represented. This was the first time a court had ever deemed a bill assent to a genuinely unprecedented remedy. So, this is the first half. In the first half, two judge bench in the Supreme Court, they held that governor has no pocket veto. So then those bills are deemed to be passed. So this is the first half of the thing. Then second half. What is the second half? The presidential reference and the November opinion. Get two dates within this half, right? Because they are separated by 6 months and a careless answer collapses them into one. So this is two halves. So comes to the part in May 2025, President Draupadi Murmu using Article 143, using 143 article, referred 14 questions back to the Supreme Court. What are those questions? Effectively asking whether that April ruling had gone too far. This was itself controversial. Opposition states this was itself controversial. Opposition states argued the reference was a disguised appeal against a binding judgment, which is not what Article 143 advisory opinions are meant to do. And passed the objection and passed the objection as a maintainability challenge before the bench itself. Then on November 2025, a five-judge constitutional bench under CJI BR Gawai in what is formally cited as in assent, assent withholding or reservation of bills by the governor and the president, delivered a unanimous advisory opinion that meaningfully walks back the April ruling on several fronts. What are they? Courts cannot fix binding timelines for the governor or president to act. There is no such thing as deemed assent. Even the Supreme Court's Article 142, complete justice, complete justice power under Article 142 cannot manufacture assent where the Constitution requires an actual decision. And most strikingly, the governor's decision on a bill is not justiciable before it becomes law. A court cannot review the merits of why a governor withheld or reserved a bill. At the same time, the November opinion did not hand the governor unlimited power. It held that prolonged, unexplained, indefinite inaction remains reviewable, and clarified that under the first proviso to Article 200, the governor really has only three options: assent, reserve for the president, or withhold and return for reconsideration, not a fourth silent option of withholding without returning. This is ruled by Supreme Court in the November itself. So here one technical point. What is the technical point? An Article 143 opinion is advisory, not a binding precedent, not a binding precedent in the strict Article 141 sense. So, yet in practice, such opinions are treated as authoritative by all courts and constitutional actors, which is precisely why this one is understood to have effectively displaced the April ruling's most novel holdings. Knowing the distinction, advisory in form, decisive in effect, is itself examinable. So, know also the political backdrop between the April ruling and the May reference, because it explains why the reference happened at all and gives you the judicial overreach debate in one quotable episode. In the weeks after the April ruling, the then Vice President publicly attacked it it in extraordinary terms, describing the judiciary as acting like a super parliament and calling Article 142 a nuclear missile against democratic forces available to the judiciary 24 by 7. Remarks that themselves triggered a counter debate about constitutional functionaries criticizing binding judgments. So the sequence you are tracing is not merely doctrinal. It is a full executive judiciary confrontation cycle. Expansive judicial remedy in April, political pushback from the highest constitutional offices in the weeks that followed, the reference in May, and then the court itself recalibrating through the advisory route in November. The that three beat structure, remedy, backlash, and recalibration, is the analytical spine of an answer any on judicial overreach this year. So, why does this matter beyond the specific case? Because it is a textbook illustration of separation of powers as a live doctrine, not just an exam term. The court itself framed its own restraint as necessary to avoid shattering the preamble walls. The court itself framed its own restraint as necessary to avoid shattering the preamble walls between the judiciary and the executive. Language you can use directly in an answer. It also reopened the entire governor versus elected government pattern. This script traced in scene 13b, replaying it now with the court's own power in question, not just the governors. Then comes to the answer writing part. The 2025 advisory opinion on gubernatorial assent to bills reflects a recalibration of the relationship between judicial review and executive discretion. Discuss. Answer should be traces the April to May to November sequence precisely. Then explains why deemed assent was constitutionally unusual and why the court itself later called it unsustainable. Then distinguish the differences between reviewing the merits of a decision and reviewing unexplained delay. Notes the advisory character of the Article 143 opinion on the maintainability controversy around using a reference to revisit a judgment, and closes by asking whether this recalibration genuinely resolves the underlying center state political friction that caused the Tamil Nadu case in the first place or merely relocates it. This is the way of the answer writing. So let us summarize simply. This is the most current, most exam ready material available on governor topic. A live sequence showing the Supreme Court itself grappling with the limits of its own remedial power decided in your revision window. Not a decade ago. And the sequence has three dates and not now. The April 8th ruling, the May reference, the April 8th ruling, two judge bench of Supreme Court. Then the May reference by President and the November 20 opinion by Supreme Court 5 judge bench led by CJI. So this is the whole thing, the 2025 presidential reference, governors and judicial overreach or liability. So these are the things you have to be very careful with. And then we are moving to next one, that is special intensive revision. Special intensive revision. The control, the electoral rolls controversy. This is extends chapter 6, scene 12b, the Representation of People Act we discussed earlier. If there is one topic almost guaranteed to appear in some form in Mains 2026, this is it. It touches the RPA, it touches the Article 324, it touches the citizenship, it touches the federalism, and it touches the fundamental rights simultaneously. And it has been continuously in the news for over a year. Actually, what happened? The Election Commission launched a nationwide special intensive revision of electoral rolls beginning in Bihar in mid 2025. The first such intensive revision since 2003, and has since extended in the phases covering most of the country, started in mid 2025 in Bihar. The exercise required voters, especially those enrolled after 2003, to submit fresh documentary proof of date of birth and parentage, going well beyond a routine annual roll update. This is the SIR. Roughly 47 lakh names were removed in Bihar alone. Tens of millions were removed in West Bengal and Uttar Pradesh in subsequent phases. So the controversy was immediate and multi-layered. Opposition parties argued that burden of proof had unfairly shifted onto the individual citizen, that the exercise excluded commonly held documents, exercise excluded commonly held documents like Aadhaar and ration cards, and that it risked disenfranchising the poor and migrants who often lack the specific paper trail demanded. Some framed it as backdoor national register of citizens exercise. The matter reached the Supreme Court, which in an interim order required to ECI to publish district-wise lists of deleted names with reasons, and to allow inclusion claims using Aadhaar. On 27 May 2026, a bench headed by CJI Suryakant with Justice Joymalia Bagchi and Vipul Pancholi delivered its final verdict in Association for Democratic Reforms versus Election Commission of India. In this judgment upholding the SIR's legality, it held that the ECI's power under Article 324 combined with Section 21, Clause 3 of the RPA 1950 permits this kind of special revision at any time for reasons recorded. That the exercise satisfies the constitutional test of proportionality given the 4 decades gap since the last intensive revision and the procedural safeguards built in. And that adapting a different procedure from a routine revision does not by itself make the exercise unconstitutional or excessive. So notably, the final judgment also upheld the ECI's discretionary power over its document list, including the exclusion of ration cards and even pre-existing voter identity cards as standalone proof, a harder position than the interim orders other accommodation. So make sure your answer distinguishes the interim relief from the final holding. So two further holdings from the final verdict are directly quotable and should be in your notes. And first one, And the role resumption. What is the role presumption? Inclusion in an existing electoral role creates a presumption of validity, but that presumption is rebuttable. It does not bar the commission from re-verifying names in a special revision. And second one, and most importantly, given the NRC framing, the court held that ECI can examine whether a person is an Indian citizen, but only for the limited purpose of deciding inclusion or exclusion from the electoral roll, and with due regard to the presumption favoring an elector already on the roll. This is the single most examinable line in the judgment, because it is court's direct answer to the citizenship screening by the backdoor critic. So the ECI's citizenship inquiry is electoral in purpose and a consequence, not a determination of citizenship status at large. So one adjacent legislative peg belongs beside SIR because it completely the citizenship and documentation picture. The Immigration and Foreigners Act 2025 in force from 1st September 2025 replaced four colonial era statutes: the Passport Entry to India Act 1920, the Registration of Foreigners Act 1939, the Foreigners Act 1946, and the Immigration Carriers Liability Act 2000 with a single framework: a statutory Bureau of Immigration, mandatory resignation, mandatory registration of foreigners on arrival, reporting obligations on hotels, universities, and hospitals, biometric capture, and sharply enhanced penalties for forged travel documents. The critics track the SIR debate exactly: centralization of discretion, thin appellate safeguards, and privacy concerns over mandatory databases. So, one linking line is available for any answer. In the same cycle, the state rebuilt both the machinery that decides who votes and the machinery that decides who enters. And both rebuilds shifted discretion toward the executive. So, why does this matter constitutionally beyond the immediate politics? Because it sits exactly at the intersection you studied in scene 12b, that is universal adult franchise. Universal adult franchise is a constitutional guarantee, but the machinery that makes it real is statutory. And that machinery can be tightened or loosened by the very body meant to protect the right. The core tension the court had to resolve is precisely the one this script has flagged repeatedly. What is that? How much administrative discretion can an accountability institution exercise before its own exercise of power itself needs external review? I'm repeating again. How much administrative discretion can an accountability institution exercise before its own exercise of power itself needs external review? Notably, commentators have pointed out that the judgment arrived 6 months after the Bihar election. It was meant to safeguard had already concluded, raising a genuine citable critique about the timelines of judicial review over electoral processes. For answer writing, discuss the constitutional basis of election commission's power to conduct a special intensive revision of electoral rolls and evaluate the concerns raised regarding disenfranchisement. Explain Article 324 and Section 21 Clause 3 RPA Act 1950 as the foundation. Then discuss the documentary burden concern and the document exclusion controversy. Cites the Supreme Court's proportionality based reasoning and its limited purpose citizenship holding. Then distinguishes the interim safeguards from the final verdict and closes with a balanced view, that is, accurate roles serve the integrity of universal adult franchise, but the process by which accuracy is pursued must not become a barrier to the very right it claims to correct. So this should be the balanced view. Accurate roles serve the integrity of universal adult franchise, but the process by which accuracy is pursued must not become a barrier to the very right claims to protect. Accuracy is important, but the pursued way also important. That is what the statement is telling. So SIR is the RPA chapter's current affairs anchor for this cycle, a genuine test of exactly the theme seen to will be raised. Does the machinery serve the right, or does the machinery quietly become a new gatekeeper for it? You have to think on these two lines. This is the main angle, and then next one we are moving to delimitation, the 850 seat debate and women's reservation. It is extends chapter 6, scene number 12, that is Parliament, and chapter 5, scene number 11, federalism. This is delimitation. This is a dense high value cluster. Three linked stories that UPSC could ask about individually are more likely together since they are legally and politically inseparable. So start with background you already have in the part 1. The 106th Constitutional Amendment 2023, the Women's Reservation Act, popularly known as the Nari Shakti Vandan Adhiniyam, reserved one third of seats in the Lok Sabha and state assemblies for women, but made the reservation contingent on a fresh delimitation exercise following the first census after 2026. What is this meant? This mean to be reservation through passed with near unanimous support in 2023 would not actually apply for years. This is not immediately application. Critics call this a deliberate delay tactic. Now comes to the current development. On 16th April 2026, the government introduced three linked bills: the Constitution 131st Amendment Bill 2026 and the Delimitation Bill 2026 and the Union Territories Law Amendment Bill 2026, aimed precisely at breaking the delay. The 131st Amendment sought to remove the requirement of waiting for a post 2026 census, instead letting Parliament decide by ordinary law which census to use for delimitation. The delimitation bill specified that the 2011 census, 2011 census, not a future one, would be used. This would also raise Lok Sabha's maximum strength from 550 to 850 seats. Here is where it becomes a genuine federalism controversy, tying directly back to the your scene 11 on federalism. What is that? What is the federalism flashpoint? Because seat allocation had been frozen at 1971 census proportions since the 42nd and 84th amendments, specifically to avoid penalizing southern states that had successfully controlled population growth using a fresh 2011 census to reallocate seats risked exactly that penalty. So, Tamil Nadu seat projected to fall from 39 to 32, Kerala's from 20 to 15, while Uttar Pradesh and Bihar would gain substantially. So, in this context, the government's counter argument was that a uniform proportional increase across all states via the 850 seat expansion would keep every state's relative share essentially unchanged. It meanings to no state would actual lose ground even as absolute numbers shifted, the union said. But southern states and opposition parties were unconvinced. They framing it as one person, one vote, one value, running headlong into decades of federal bargain protecting less populous, higher growth control states from being outvoted by more populous ones. And here is the analytically sharp detail worth citing we have. What is that? The proportional share assurance was given verbally, not written into the bill's text. And the opposition's two stated conditions for consensus were precisely that any proportional guarantee be placed in the text itself and the woman's reservation be delinked from delimitation altogether. So the bill failed not merely on federal arithmetic, but on a trust deficit about an unwritten promise that is absolute share, a distinction that elevates an answer from descriptive to analytical. So the result matters as much as the proposal as far as this amendment bill. On 17th April 2026, the 131st Amendment Bill was defeated in the Lok Sabha. It received 298 votes in favor against 230 against, well short of two-thirds special majority, that is 352, with 528 members present and voting. A constitutional amendment requires. Following the defeat, the government withdrew the associated bills. This itself a rare and citable example of constitutional amendment bill actually failing on the floor of the House. Worth remembering as a counterpoint to the amending power is nearly unlimited in practice, framing some students' default to. This is itself a rare and citable example of a constitutional amendment bill actually failing on the floor of the House. This is worth remembering as a counterpoint to the amending power. Amending power is nearly unlimited in practice. For that point, this is the counterpoint. So, here the note layered consequences because the delimitation and 850 seat route failed. The Women's Reservation Act through formally notified into force on 16th April 2026 remains inoperative in practice since the 33% reservation itself is still tied to the pending delimitation exercise. But opposition wants to delinks women's reservation from that delimitation exercise. This is a good example of law being in force on paper while remaining without practice effect. A distinction UPSC likes testing. Law being in force on paper, law being in force on paper while remaining without practical effect. A distinction UPSC likes testing is. Comes to the answer writing part. Examine the constitutional and federal challenges associated with linking women's reservation in legislatures to a delimitation exercise based on updated census data. Answer should be explain the 106th Amendment's original design and its delay critique, then describes the 2026 attempt to accelerate implementation via the 131st Amendment and a delimitation bill, then analyzes the southern states federalism objection rooted in the 1971 census freeze rationale, and then discusses the government's proportional increase counter argument and the fact that it was never written into the bill's text. It is verbally said regarding absolute share, relative share, and closes by noting the bill's defeat as evidence that even a government with a parliamentary majority cannot always secure the special majority a constitutional amendment demands. This is a live illustration of the amending power limits the script studied in scene 10, the basic structure doctrine. So this cluster ties together parliament's structure, the federal seat allocation bargain, and gender representation into a single life story and its unresolved status as of this revision makes it exactly the kind of developing situation UPSC likes to test candidates' ability to track reason through not just recall. Then comes to the next scene, that is one nation, one election. This is where it actually stands. This is the extends scene number 12, that is Parliament, and scene number 12B, that is RPA, Representation of People's Act. This is status. Precision is the whole scene we are going to discuss. The Constitution 129th Amendment Bill 2024, along with a connected Union Territories Laws Amendment Bill, was introduced in December 2024 to enable simultaneous Lok Sabha and State Assembly elections, the culmination of a high level committee chaired by former President Ramnath Kovind. So both bills were referred to a joint parliamentary committee chaired by PP Chowdhury. As of the most recent extension, that is, the Lok Sabha has pushed the JPC, that is Joint Parliament Committees, reporting deadline to the first day of the last week of the 2026 monsoon session, meaning that the committee is still actively deliberating and no final parliamentary vote has occurred. So the constitutional mechanism are worth knowing precisely. So implementing one nation and one election requires amending Articles 83 and Article 172, that is duration of houses, and Article 85 and Article 174, that is dissolution and prorogation. So, and creating a mechanism for handling premature dissolution of a state assembly mid-cycle without triggering a fresh nationwide cycle. So because this touches the composition and tenure of state legislatures, it plausibly requires ratification by at least half of the states under the Article 368 proviso. Precisely the special federal amendment category you studied under the Constitution's blend of rigidity and flexibility in scene number 9. So, so here the core policy debate mirrors the very same federalism versus efficiency tension running through this entire chapter. What is this federalism versus efficiency tension running through this entire chapter? That is, proponents argue simultaneous polls reduce cost, reduce the disruptive effect of the repeated model code of conduct on governance, and improve voter turnout. But comes to the opponents, against, argue that it privileges national issues and national parties over regional ones, risks reducing state elections to a referendum on the center, and concentrates enormous logistical power in the ECI's hands at a single moment. So comes to the answer writing part. Examine the constitutional amendments required to implement one nation, one election, and assesses whether the proposal strengthens or weakens federal principles. A high scoring answer lists the specific articles requiring amendment, then explains the state ratification requirement given the constitution's impact on legislature tenure, and then discusses the efficiency argument and the federalism or regional party objection on both sides even handedly, and notes the proposal's current procedural status. Still with a JPC, not yet before Parliament for a final vote, showing you how to track, you are tracking the live status rather than treating it as settled law. So do not write about one nation, one election as if it has been implemented. As of this revision, it remains a bill under committee scrutiny, and getting the status right itself worth marks. So this is all about regarding one nation, one election. It is currently under JPC scrutiny. So we are moving to next scene, that is judicial accountability after Justice Varma case. That is resignation and the verdict that may outlive it. Judicial accountability after Justice Varma case. What is this? It extends chapter 8, scene 14, the judiciary. This is the single richest current affair story for the judiciary chapter, and it deserves careful, precise sequencing because UPSC loves testing procedural detail on judicial removal. It is recalled the 2016 Coelho and basic structure question style. And a warning at the outset. The scene, this scene, unlike most in this part, changed shape as recently as the revision window. So the ending you may have read in older material is no longer the ending. So what is the trigger here for this Justice Verma case? On the on the night of 14 to 15 March 2025, a fire at the official Delhi residence of Justice Yashwant Varma, the then a judge of the Delhi High Court, led firefighters to discover partially burnt currency in an outhouse on the property. After this, Justice Verma denied any knowledge or ownership, calling the storeroom a general dumping area accessible to domestic staff. After that, he was swiftly transferred to the Allahabad High Court and given no judicial work pending inquiry. The in-house mechanism and where it stopped. Then CJI Sanjeev Khanna constituted a three-member in-house inquiry committee under judicial custom, which found strong interferential evidence of Justice Varma's control over the storeroom and recommended removal. In an unusual step, the Supreme Court itself published the preliminary report, photographs and video of the burnt currency online. A significant transparency move breaking from the judiciary's traditionally closed internal process with this. Justice Varma refused to resign because the in-house process alone cannot remove a judge, but only Parliament can, through the removal mechanism under Articles 124 Clause 4 and 217 Clause 1 Subclause B and the Judges Inquiry Act 1968. The CJI forwarded the findings to the President and Prime Minister, formally recommending initiation of the constitutional removal process. The parliamentary and judicial phase, and note carefully that parliamentary and judicial phase, Justice Varma litigated twice at two different stages and lost both times. What Justice Varma did? First, he challenged the in-house procedure itself before the Supreme Court. A bench of justices Deepankar Datta and A.G. Masi dismissed that petition. Probably this is memorably affirming that the CJ is not a mere post office passing along a committee's findings without independent judgment. With dismissing the petition, it is memorably affirming that the CJ is not a mere post office passing along a committee's findings without independent judgment. That famous line belongs to this first challenge. Meanwhile, over 100 Lok Sabha members signed a motion for removal, and the Speaker constituted a formal three-member inquiry committee under the 1968 Act in August 2025. Then Justice Varma mounted his second challenge, this time to the Speaker's decision to admit the removal motion on procedural grounds, and the Supreme Court dismissed that too in early 2026, holding the Speaker's action valid. Two separate challenges, two separate dismissals, one to the in-house track and one to the parliamentary track. Then what happened? There's resignation and the twist. What is the twist? On 9th April 2026, with the inquiry committee on the verge of concluding its proceedings, Justice Varma resigned. Through writing to President Draupadi Murmu under Article 217, Clause 1, Subclause A, with immediate effect. With immediate effect, simultaneously withdrawing from the committee's proceedings, alleging denial of a fair hearing, including the inability to cross-examine key witnesses. Now the assumption, what is that assumption? Most commentary made in April, and which older notes may still carry. What is that older note? was that resignation automatically abates the inquiry? Since the 1968 Act's process is aimed at a sitting judge, here is why this scene needed rewriting. That assumption has not held. The statutory committee continued its proceedings ex parte, finalized its findings, and submitted its report to the Speaker in May 2026. And the Speaker has announced the report will be tabled in the Lok Sabha during the monsoon session beginning 20th July. So, the genuinely open constitution question here is live live in your revision window. Is this what can Parliament do with an inquiry report against a judge who no longer holds office? Already he resigned. Removal itself is moot. There is no office to remove him from. But a tabled report creates a formal public parliamentary record of the findings. And supporters of continuation argue the 1968 Act nowhere says the inquiry must stop on resignation. And that accountability cannot be defeated by well-timed exit. So situate it against the precedents because the sequencing differences now matter more than ever. This is the third instance of a High Court judge resigning to forestall a parliamentary verdict on removal. But each exit point differs, and Varma's is now distinct from both. Comes to the Justice P.D. Dinakaran, resigned in 2011 while the inquiry committee was at work, and the Rajya Sabha chairman wound the committee up. Resignation ended the process. Then comes to the Justice Saumitra Sen. He resigned later in the process after the Rajya Sabha had passed the removal motion, but before the Lok Sabha could vote, leaving him on one reading, impeached through never removed, impeached thou never removed, since the committee's adverse report remains on the public record. But comes to the Varma is the new third path. Resignation before any parliamentary vote, but a committee that refused to fold, pushing toward the same outcome by a different route. Whether Parliament actually tables and acts on the report is the bit to watch. The constitutional gap restated with precision. What resignation still secures on any reading? It forecloses removal and with it formal removed for proven misbehavior label. And pension accrues under the service law framework subject to qualifying service. What resignation may no longer secure? And this is the reform question in real time. In escape from a published verdict, the standing reform proposal your answer should carry. Amend the 1916 8 Act to state expressly that an inquiry, once constituted, proceeds to a published conclusion regardless of resignation, purely for the public record, converting what the Varma committee did by improvisation into a statutory rule. So comes to this part, with resignation, the process should not be end. It should be recorded with public. That is what is trying to say in this particular paragraph. Then comes to the answer writing part. Constitutional guaranteed judicial independence is a prerequisite of democracy. But recent events reveals gaps in judicial accountability mechanisms discussed with reference to the Justice Varma case. First of all, answer explains why judicial independence requires a removal process insulated from ordinary executive control. Then hence the deliberately difficult route under Article 124, Clause 4 traces the Varma sequence precisely from the fire to the Article 217, Clause 1, Subclause A resignation. Then notes both dismissed challenges. Then the ends its marks on the ending. The committee's ex parte continuation and the pending table of its report. The contrast between Dinakaran process wound up and comes to the same. In the same case, verdict half delivered and the statutory amendment reform. Close on status discipline. As of this revision, the report stands submitted. Its tabling announced for the session beginning 20th July. So the final shape of this precedent may be set while you revise. This is the way of the writing an answer regarding this particular question. 4 beats here, not 3. The fire and the in-house finding. The fire and in-house finding. Then 2 failed challenges. The 9th April 2026 resignation and the corrected ending. The inquiry that did not die. With its report awaiting Parliament in the monsoon session. The accountability gap this scene teaches has narrowed from resignation, closes the file to resignation forecloses removal, but perhaps not the verdict, and whether that perhaps hardens into precedent is the single most watchable judiciary development between and your exam now and your exam. So this is not end here. So this is regarding judicial accountability after Justice Varma. Then comes to the next scene, that is the Waqf Amendment Act 2025, the secularism and property rights before the court. This is the extends chapter 4, scene number 9, that is salient features of Indian Constitution, that is secular democratic republic, and chapter 8, scene number 14, that is judiciary. The secularism theme is scripturized early on for this current affairs anchor. You have to worth knowing in structured detail rather than headline form. Since the Supreme Court's interim ruling is unusually analytical. This is regarding the Waqf Amendment Act 2025. This is renamed the Governing Framework, the Unified Waqf Management, Empowerment, Efficiency and Development Act, and made several significant changes. What are the changes? It abolished Waqf by user, meaning a property could no longer be treated as Waqf merely by long-standing religious use without a formal deed. It required mandatory resignation with documentary proof. It mandated inclusion of non-Muslim members on the Central Waqf Council and state Waqf boards. And most controversially, it created a mechanism in section 3C allowing a government officer to determine that a disputed property is government land rather than Waqf property pending resolution. What is the section 3C says? Allowing a government officer, it is created It created a mechanism allowing a government officer to determine that a disputed property is government land rather than Waqf property in pending resolution. Over 65 petitions were filed challenging the act as ultraviolence the constitution. As ultraviolence the constitution, invoking articles 14, 15, 19, 21, 25, 26, 29, 30, and 300A articles. An unusually broad rights invocation worth remembering as an example how a single statute can implicate equality, religious freedom, minority educational rights 29, and property rights simultaneously 300A article. But the Supreme Court's interim ruling on 15 September 2025 is a good model of exactly the balanced constitutional reasoning. This script has repeatedly told you UPSC rewards. It neither struck down the act nor upheld it wholesale. It stayed the government property provision under Section 3C insofar as it allowed a mere doubt about government ownership to strip Waqf states without judicial adjudication, holding that determining property title is inherently a judicial, not executive function, a clean separation of powers point you can cite directly. What Supreme Court said, interim ruling, neither stuck nor upheld wholesale. Neither struck nor upheld wholesale. 3C stayed. Title determination is inherently judicial. Clean separation of powers ground. The 5 years practicing Islam proof stayed. No verification mechanism. Failure of implementability, not substance. It stayed government property provision under Section 3C insofar as it allowed a mere doubt about government ownership to strip Waqf status without judicial adjudication, holding that determining property title is inherently a judicial, not executive function. A clean separation of powers point you can cite directly. That is said by Supreme Court ruling. It is also state the requirement that a person prove they have practiced Islam for at least 5 years before creating a Waqf. Not because the requirement itself was invalid in principle, but because no mechanism existed yet to verify it. A good example of provision failing not on substance but on implementability. 5 years, 5 years practicing Islam, proof stayed, no verification mechanism. At the same time, the court upheld the prospective abolition of Waqf by user, reasoning that Parliament retains the legislative competence to redefine what qualifies as Waqf going forward, and upheld the mandatory registration and deed requirements as consistent with a documentation obligation that has existed since 1923. So, why does this matter for the broader secularism theme? It is a live test of exactly the balance scene 9 described so far: equal respect and equal protection for religious communities, not hostility, but also not total insulation from ordinary, regulatory, and property law. So the core disputed question here is how far can the state legislature, sorry, how far can the state regulate the administration of a religious community's charitable endowments without infringing Article 29? Remains open. Since this was only an interim order, final adjudication is still pending as of this revision. So comes to the answer writing part. Discuss the constitutional issues raised by the Waqf Amendment Act 2025 with reference to the Supreme Court's interim ruling. A high scoring answer explains the key changes the Act introduced in the first instances, then situates the challenge within Article 25 and Article 26 and Article 300A. Explain precisely which provisions were stayed and on what specific constitutional ground, and separation of powers for the government property provision, then implementability for the 5 years practice class, and which were upheld and why, and closes by noting the matter remains sub judice. So any answer should present the interim position as provisional, not final. So let us summarize this. This case is valuable and precisely because the court's own reasoning models the balanced, ground by ground analytical style. Some provisions uphold and some stayed, and each on a distinct constitutional principle. That a high scoring UPSC answer should imitate structurally, not just cite as a content. So this is regarding Waqf Amendment Act 2025 and changes, introduction, uproar, Supreme Court ruling, interim ruling, and sub judice, not final, etc. Then we are moving to scene number 32, that is Jammu and Kashmir, the unfulfilled statehood promise. This is extends chapter 7, scene 13A supplement, that is Union territories. In previous classes, we discussed Union territory, already covered the legal architecture in depth. This is purely the status update. That is why I'm clarifying you again. From recalling previous classes, the Jammu and Kashmir Reorganization Act 2019 converted the former state into two union territories, that is Jammu and Kashmir with a legislative assembly and Ladakh without legislative assembly. On 11 September 2023, a constitution bench of the Supreme Court, while upholding the abrogation of Article 370 itself, specifically directed the Union government to restore Jammu and Kashmir's statehood and to hold assembly elections. In 11 December 2023, a constitution bench of Supreme Court upholding specially directed Union government to restore Jammu and Kashmir statehood and to hold assembly elections. Assembly elections were in fact held in late 2024, restoring an elected government under Chief Minister Omar Abdullah, but statehood itself, the actual restoration of Jammu and Kashmir from Union territory to full state status, has still not been completed as of this revision. So the Prime Minister has repeatedly reiterated the center's commitment to eventually statehood restoration in public statements through 2026. But till now, no formal legislative timelines has been announced. So why keep this on your radar for Mains 2026? Why? Because it is precisely the kind of elected government functioning under incomplete constitutional status. This is scenario Your union territories seen flagged as Jammu and Kashmir's distinguishing feature compared to Delhi. Except here, unlike Delhi, there is an explicit Supreme Court direction still pending full compliance, which is itself a rare and citable instance of a constitutional court directing the union to take a specific federal structural action, and that direction remaining open over 2 years later. Constitution bench directed 11th December 2023 regarding full statehood directed, but till now it is open. Comes to answer writing part. Assess the current status of Jammu and Kashmir's constitutional position in light of the Supreme Court's 2023 direction on restoration of state. Comes to the answer. Traces the 2019 reorganization, then the 2023 Supreme Court judgment upholding Article 370's abrogation while directing statehood restoration, the 2024 Assembly elections as partial compliance, and the continuing gap between the elected government and full statehood. Before evaluating the security, administrative, and political considerations likely shaping the center's cautious pace. So this is a short but live current affairs thread. You have to know precisely what has happened and what has not happened. Happened that elections held in 2024. Has not happened statehood, restoration of statehood. Because UPSC rewards exactly the kind of precise status tracking over vague. So Jammu and Kashmir is now a union territory, summarizes. So this is regarding about Jammu and Kashmir unfulfilled statehood promise. Then comes to the who selects the empire scene number 33. That is the CEC Appointments Act before the court. So this is the extends chapter 6, scene 12b, the RPA and the Election Commission, and chapter 8, scene 14, the Judiciary. The one final scene, and it pairs deliberately with scene number 27, because if SIR was about what the election commission can do, this is about who gets to decide who the election commission is. Together they form a complete guardian institution. Question. And UPSC could easily link them in a single prompt. So the background you carry from scene 12b in Anup Baranwal versus Union of India, March 2023, a 5 judge Constitution bench unanimously held that in the absence of parliamentary law, Article 324, Clause 2 contemplates the CEC and election commissioners would be selected by a committee of the Prime Minister, the leader of the opposition, and Chief Justice of India, expressly as a stopgap till a law is made by Parliament. Stopgap till a law is made by Parliament. Parliament made that law within months. The Chief Election Commissioner and other election commissioners' appointment conditions of service and Term of Office Act 2023, which replaced the CJI on the selection panel with a Union Cabinet Minister nominated by the Prime Minister, restoring an effective 2 to 1 executive majority. It leaves LOP in 2 to 1 executive majority. Appointment have since been made under this act, including Ganesh Kumar as CEC in February 2025. Even as petitions by ADR, Cheya Thakur, and others challenging the act's validity remained pending. The court had declined to stay the act or the appointments the interim. Why? What is the current development? After 2 years of listings, the challenge finally reached substantive arguments in May 2026 before a bench of Justices Deepankar Datta and Satish Chandra Sharma. CJI Suryakant having recused in March 2026. Two threads from the hearings are worth knowing precisely. What is the first thread? The bench's own oral observations were pointed. It questioned why a cabinet minister should sit on the panel at all when the prime minister is already there. Observe that 2 to 1 composition renders the leader of opposition's presence effectively ineffective. So contrast it with the CBI directors panel, which includes the CJI as an independent member, and remarked that the commission must not only be independent but appear independent. The appearance of neutrality principle, from natural justice. And comes to the second thread, the bench also flagged that the counter question that makes this a genuinely two-sided issue. That is, Baranwal itself said its formula would operate only until Parliament legislated. Parliament has now legislated. So can the court now direct Parliament to enact a particular kind of law or strike down the composition of Parliament choose? That is separation of powers cutting the other way. And a balanced answer must give it to full weight, not treat the outcome as foregone. So one third is why again cabinet minister, prime minister itself in the member of that committee with 2 to 1, 2 by 1. LOP is inefficiently effective, ineffective efficiently. Then second thread, after directing, Parliament has now legislated after the court directions. So can the court now direct to Parliament to enact a particular kind of law or strike down the composition of Parliament choose? It is separation of powers using discretion, using judicial review or not. You have to write a balanced answer. That the status as one of these revision arguments had no final verdict delivered. So exactly as with one nation, one election, do not write about this is as settled because 28th May, this is under scrutiny of JPC, then present it as live constitutional question with the framing intact. The Constituent Assembly's consensus that elections be managed by a body taken out of the hands of the government of the day versus Parliament's undoubted competence under Article 324, Clause 2 to legislate the appointment process it refers. So, why this scene ends its place in Part 3? It is the purest available example of the question running underneath this entire chapter. Who guards the guardian? SIR asked whether the ECI's own exercise of power needs external review. This case asks whether the process that constitutes the ECI needs insulation from the very executive whose elections it refers. So same institutions, both directions. Comes to the answer writing part. The independence of the election commission begins at the stage of appointment. Critically examined in light of the Chief Election Commissioner and other Election Commissioners Act 2023. A high scoring answer first and foremost traces Article 324 Clause 2 subject to a law made by Parliament. Design, that is, the Anup Baranwal stopgap formula and its self-limiting language. The 2023 Act's substitution of the CJI with a cabinet minister, the pending challenge and the court's appearance of independence observations, and the counter argument that parliament acted precisely within the space Baranwal itself preserved, closing on the current sub judice status rather than a predicted outcome. You have to know three things cold. What are the three things? What Paranwal held and its self-limiting caveat, what the 2023 Act changed, and the fact that challenges is ignored but undecided as of this revision. So status precision, once again itself worth marks. So this is regarding who selects the empire. Who is the empire? CEC. CEC, Chief Election Commissioner. So we will move to the next class. We will move in the next class. We are going to discuss private property and the community's resources. That is scene number 34, the 9 judge verdict on Article 39B.